Good morning. Welcome to the Denton's in-house Counsel CLE webinar series. And today's first of two programs is a legal update and segment on practical tips for employers doing business in California. Before we get started with the program, I have some housekeeping matters to attend to. So first of all, for the benefit of all participants, attendee lines have been muted. If you have any questions you'd like to submit during the program, you may submit them through the question and answer space. If we can't answer your question during the webinar, we will follow up after the program. Note that the webinar will be recorded and circulated to all registrants via email after the event. If you have follow-up questions at that time, please reach out to any of the key contacts listed in the email communication. Note that Denton's can only issue CLE credit if you attend on a computer or laptop device. Credit is not available for joining via mobile device. One other important note, if you have a New York, New Jersey, Pennsylvania, or Kansas license, listen for the code word given during the program. When prompted, you'll need to enter the code word in the Q&A section of the screen. If you're not licensed in New York, New Jersey, Pennsylvania, or Kansas, don't worry about the code word. Today's agenda will consist, first of all, of my introduction, a California legislative roundup, a discussion of restrictive covenants and the all-important wage and hour overview, and we'll conclude with one of my favorites, practical tips for California employers. Joining us today for this segment are me, Sandra McCandless. I'm a partner in the San Francisco Bay Area practicing in labor and employment, and labor and employment associates Jessica Peterson of the Bay Area and Carl Lehman of San Diego. So for the introduction and a brief overview. California has the most comprehensive employment laws in the United States. And I'm always surprised because I find that many clients, particularly those overseas, but even in the US, are still at times unaware of that. We have a 700-page labor code, and among other things, Industrial Welfare Commission wage orders, which regulate wages, hours, and working conditions by industry. New employment laws provide additional protections to employees and create new obligations on employers every single year. The California requirements, the labor code, and the case law, the thousands of cases interpreting our California requirements increase every year. Legal compliance becomes more and more complicated. Wage and hour class actions continue. And for those of you who have never experienced a wage and hour class action in California, we'll address that somewhat today. But I can tell you that our very burdensome California wage and hour rules make for extremely messy and expensive wage and hour class actions. We have an onerous system of penalties for violation of the California wage and hour rules. I tend to say that $1 will get you 10, and $10 of violation will get you $1,000 of penalties. There have been many significant employment changes in 2023. The list of new employment and labor laws which are actually passed runs 10 pages, and we will address what we see as the most important for you on this program today. It's worth noting that Governor Newsom did veto quite a number of pro-employee bills, including the California WARN Act provides for WARN Act notice in certain situations where federal notice does not apply. The legislature proposed that notice be extended from 60 days to 75. Governor Newsom vetoed that bill. There was a proposal to outlaw caste discrimination put forth by many in the South Asian community. The governor noting that he felt that that some of the new laws were either vague or, in his view, duplicative of existing law. He vetoed the caste discrimination law and also vetoed new discrimination harassment protections for family caregivers. I note, however, that the fact that the new protections for family caregivers were vetoed does not mean that a family caregiver will not have protection. There are many other laws protecting people on the basis of membership in protected classes. And so a family caregiver is likely to be able to find some other law on which to rely in making a discrimination claim. The governor also vetoed a 30-day written notice requirement for return to the office and payment of unemployment benefits to striking workers. One of the reasons for vetoing unemployment benefits to striking workers is the governor noted that our state coffers are not so rich that the state should be adding additional payments to workers who strike at this time. But we may see these vetoed bills return in the future. Our legislature continues to be active, and if they've tried to pass these bills once, they will do so again. The next segments of the program will focus on those significant new employment laws and case law that did pass or are in existence. And so for the legislative roundup, I turn the discussion over to Jessica Peterson, who will begin with off-duty cannabis use.
Hi, everyone. I'm Jessica Peterson. I'm a managing associate here at Denton's in the Bay Area. I've been practicing in the employment space for about 5 years now, and I've been at Denton's for about 1.5 years. I'm here to walk through a legislative roundup of a few new laws coming into effect in 2024. So let's get started here, as Sandy said, with off-duty cannabis use. Senate Bill 700 and 2188 prohibit employers from taking adverse actions, including discriminating against a person in hiring, termination, or any term or condition of employment based on off-duty and away from the workplace cannabis use. Further, it is generally prohibited to use information regarding previous cannabis use obtained from a criminal background check unless it is in compliance with state laws. That said, on-duty impairment, use, possession of cannabis may still be prohibited. This law also carves out certain industries like construction, as well as federal grant recipients and contractors, federal contractors, excuse me. These laws don't preempt federal or state laws, and these laws, excuse me, go into effect on January 1 of next year. Moving on to increased paid sick leave, Senate Bill 616 increases the number of paid sick leave hours from 24 hours or 3 days to 40 hours or 5 days. This goes into effect on January 1 of next year. Employers are still allowed to front load paid sick leave, so giving it all to employees at once, or let employees accrue over time. If employees are accruing paid sick leave over time, they should accrue 1 hour of leave for every 30 hours worked. And this new law puts in place a requirement that employees must accrue at least 24 hours of paid sick leave by their 120th calendar day of employment, and at least 40 hours of paid sick leave by their 200th calendar day of employment. Employers are allowed to cap accrual at 80 hours or 10 days of paid sick leave, and use is can be limited to 40 hours or 5 days each calendar year. As I mentioned before, this goes into effect on January 1, 2024. Next is a new leave entitlement for employees for bereavement, new bereavement leave for employees for reproductive losses. This is from Senate Bill 848, and employees who have worked for at least 30 days are entitled to up to 5 days of reproductive loss leave. A reproductive loss is defined as a failed adoption, surrogacy, miscarriage, stillbirth, or unsuccessful assisted reproduction. Employers are allowed to limit use to a maximum of 20 days in a 12-month period. And employers cannot retaliate against employees for using this leave. This leave also goes into effect on January 1 of next year. Moving on, next slide, to the new presumption of retaliation for discipline or discharge for certain protected conduct. This comes from SB 497. It amends various sections of the California Labor Code and creates a presumption of retaliation against an employer who takes an adverse action against an employee within 90 days of reporting a wage and hour violation, disclosing a violation of law to a government agency, or enforcing their rights related to equal pay. This law goes into effect on January 1, 2024, and it is another enhancement for employees to be protected from discipline and discharge. Finally, moving on to the Workplace Violence Prevention Plan, which goes into effect on July 1, 2024, employers will be required to create and implement a workplace violence prevention plan, which includes procedures and policies for identifying workplace violence, reporting violence, anti-retaliation, and protocols for employer response, investigation, and communication. Examples of violence include direct physical assault and credible threats of violence. In addition to having this plan in place, employers are required to record in a log every workplace violence incident that comes up. These logs must be retained for 5 years, and when this plan goes into place, employers must provide employees with initial training so they understand how the plan works, how each of the protocols and policies are, work kind of on the ground. And then every year thereafter, this training will have to be repeated. And so moving on to, what does this mean for you? This means that for all of the laws coming into effect on January 1, 2024, you may need to update your employee handbook, including your anti-discrimination, anti-retaliation, drug use, leave of absence, and paid sick leave policies. You should get ahead of the effective date of the Workplace Violence Prevention Plan. It goes into effect in July, but it is a pretty onerous requirement, and it will require, crafting a lot of new policies and plans, training programs, etc. And so we recommend, getting ahead of the effective date and getting that plan into effect before July of next year. And then finally, you should continue to seek advice from your legal department, counsel, and human resources related to existing personnel practices and how they will be impacted by these new laws. I'm going to turn it over to my colleague, Carl, for a discussion on restrictive covenants.
Thanks, Jessica. Hi, everyone. So if you thought that Jessica and Sandy, they discussed a lot of new employment laws being enacted in California, well, I'm going to pick up right at where they left off and talk about two additional bills that were signed into law this legislative cycle. And these two particular bills, they relate to non-compete agreements in the context of restrictive covenants. First, And both these bills should be kind of viewed in context of each other, and they complement each other in some ways. But starting with AB 1076, as many of you are likely aware, California has long taken a negative approach towards non-compete agreements. And since 2008, they've essentially been completely banned in California under a California Supreme Court decision. And AB 1076 is an extension of this ban, this judicial ban on non-compete agreements, and codifies it into statute. And unlike other states, California does not allow for non-compete agreements which are reasonably limited in time, geography, or industry, which is an approach that many other states take, allowing non-compete agreements if they're limited in scope. Rather, and to quote the new statute, non-compete agreements in California are void no matter how narrowly tailored. Now, with that being said, there is one very narrow exception that California recognizes, in that narrowly tailored non-compete agreements may be allowed in certain circumstances involving the sale or transfer of business ownership, with the idea being when business ownership interest is transferred to an employee, there should be a non-compete agreement to prevent the seller from competing with the buyer's business. And that's one of the very limited exceptions to the ban on non-compete agreements. And AB 1076, in addition to extending this pre-existing ban, also creates an affirmative duty for employers who have previously used non-compete agreements in California to actually give notice to employees who sign them that their agreements are now void, which this notice needs to be given by February of next year. And you'll see why this is particularly important in light of the other bill that was enacted, SB 699. Now, SB 699 goes a bit further, and it makes it unlawful for an employer to attempt to enforce an arbitration or a non-compete agreement in California. And the prohibition, it even applies if the employee worked outside of the state of California and signed an agreement in a state where non-compete agreements were allowed. So the employee works in another state that allows non-compete agreements. They entered into the agreement, and then they moved to California and began competing with their former employer. Well, this law would potentially create a private cause of action for the employer to void the non-compete agreement. And it even raises the litigation risk and stakes by allowing the employee to recover costs and attorney's fees related to voiding their non-compete agreement. So when these two laws are read together, if the employer has used non-compete agreements, they now have a duty to inform employees that they're void, and they have less ability to enforce non-compete agreements, even if they were entered into outside of the state. With one wrinkle, I anticipate the extraterritorial aspect of SB 699. I anticipate that there will be litigation over that due to the constitutional implications of going across borders and that nature. So I don't think that'll be the last we hear of that issue. And so I think this question of non-compete agreements and their viability in California raises another obvious question. And that is, what is the status of sister provisions in the form of non-solicitation agreements? And unlike non-compete agreements, where the nail has been driven into the coffin of non-compete agreements, there's still a lack of clarity about how enforceable non-solicitation of employee and customer provisions is in California. There's a longstanding case in the state that held that non-solicitation provisions that are reasonable and limited in scope are enforceable. However, in 2018, an intermediate California Court of Appeal held that a non-solicitation provision in that case was not enforceable because it was an unlawful restraint on trade. And the scope of that 2018 decision has been debated. people have wondered whether it was limited to the specific facts of that case or it has broader implications. I anticipate, like with other issues, we'll see more litigation moving forward, and I anticipate more legislative action on this point now that non-compete agreements are so to say in the rearview mirror. But regardless, even though the law is unclear, I think California employers it would behoove them to proceed with caution with respect to using non-solicitation provisions. Okay. And then turning to another hot button restrictive covenant issue, I'd like to take a moment to talk about arbitration agreements. Most of us, I think, would be aware that arbitration agreements have some obvious benefits, and they also have some drawbacks. Probably the most well-known visible benefit of arbitration agreements is the ability to waive trial by jury and to proceed with a lawsuit in a private setting in arbitration. And this can be particularly valuable if the case involves very sensitive or hot button claims. Of course, the private nature of arbitration also means that there's an increased cost, both associated with the increased cost of paying the arbitrator to hear the case, which at least in California, those rates seem to go up every year and have increased significantly, I would say, in the past 5 years. But then there's also a cost related to preparing the arbitration agreement, rolling it out to your workforce in an effective manner, and staying abreast, because the law changes so quickly on this topic in particular. An employer has to stay abreast of changes in the law, which may affect whether their arbitration agreements need to be updated. So there is an increased cost associated with them. And I mentioned it, but another drawback relating to rollout of arbitration agreements is that in California, and I'm sure in other areas, we're seeing an increased skepticism by employees with respect to arbitration agreements. So employers have to weigh the benefits and the drawbacks with respect to rolling them out that it might have on their workforce's morale, because employees are, like I said, increasingly wary of signing arbitration agreements. Now, despite these drawbacks, arbitration agreements have, in my opinion, a major benefit that outweighs other benefits or drawbacks, and that is the ability to waive class action standing via an arbitration agreement. As Sandy mentioned, and as we'll discuss in further detail in a few minutes, wage and hour class action litigation is probably the biggest threat facing California employers right now. And depending on the size of your workforce, a well-drafted arbitration agreement, the class action waiver, can significantly reduce your liability exposure for wage and hour violations. And I like to think about it this way. It protects your business both on the front end and the back end. The arbitration agreement in your handbook, when an employee is terminated and they're speaking to an attorney, the arbitration agreement from the very beginning indicates to opposing counsel that this case, from a class action perspective, may not be as valuable. And then on the back end, if you're in the unfortunate situation where you have active litigation, it also significantly reduces your damage liability exposure model and may put you in a better position to resolve the case in a cost-effective way. So despite the very significant benefits of class action waivers and arbitration agreements, there is, of course, a fly in the ointment. And in this case, it is PAGA claims. So for those of you that are not familiar, California has a statutory system called PAGA, or the Private Attorneys General Act, which allows employees to bring lawsuits on behalf of the state of California in a representative capacity for violations of the California Labor Code. And the structure of PAGA allows the employee not to just recover for violations they personally experience, but also violations that other employees in the applicable time period suffered. And the PAGA claims, they operate very similar to class actions in that sense, in that it aggregates the claims of employees and greatly increases liability, with the caveat that there's no class action approval mechanism to kind of serve as a check on class actions. And although they resemble class actions, the California Supreme Court has held that PAGA claims cannot be waived through a representative action waiver in an arbitration agreement. And this, I'm sure many of you are familiar with the progression of litigation in this area, where it went to the Supreme Court in the case Viking River Cruises, and employers appeared to get a win, but when it came back to the California Supreme Court this year in the Adolph v. Uber case, California court essentially held that no, a case can proceed despite a representative action waiver and arbitration agreement. An employee can still represent other employees' interests in state court under PAGA. So in short, a class action waiver may greatly reduce your wage and hour liability, but it will not dispose of a PAGA claim. It's not a silver bullet to get rid of all representative actions in California. And PAGA claims are typically, if not nowadays, it's almost always asserted in conjunction with a class action claim. Okay, before I move off of arbitration agreements, I just want to very quickly touch on kind of an ongoing debate in the arbitration agreement sphere. And that's whether employers are allowed to use mandatory arbitration agreements, which are a condition of employment, or if all arbitration agreements need to be made voluntary. And in 2019, California attempted to ban mandatory arbitration agreements, which then was litigated for several years. And eventually the Ninth Circuit said they allowed the law to go into effect, but then very shortly thereafter, they reversed their decision. And there's a preliminary injunction that's preventing this law banning mandatory arbitration agreements from going into effect. And while that case is still milling around in the trial court, right now, mandatory arbitration agreements under the FAA are permitted in California. But I would just flag for all of you that while it might be technically allowed, there's a lot of considerations going into whether to roll out mandatory arbitration agreements. And there are some alternative approaches other than just making arbitration agreements a condition of employment that may work just as well and may have not as severe an effect on workforce morale. So I just flag that as a potential alternative. Okay. And last out of the restrictive covenant world, I want to briefly talk about confidentiality and non-disparagement provisions. And this first bullet point is not California specific, and it's been in the news much over the last year, but I just want to flag that the National Labor Relations Board, we are seeing continued focus by the NLRB on the use of confidentiality and non-disparagement provisions in agreements with non-supervisory employees. And the big decision in this realm was the McLaren-McComb decision, which I believe came out in the spring of this year. And in California, employers, they need to be aware of the existence of an act called the Silence No More Act, which says that it restricts the use of confidentiality and non-disparagement provisions in severance or settlement agreements. It restricts the ability it prohibits an employer to restrict an employee's ability to disclose information relating to unlawful acts in the workplace. Now, the statute does include an exception in the case of negotiated settlement agreements, but in many ways, it's a better safe than sorry position on whether to include prophylactic language on this point, since what constitutes a negotiated settlement agreement is up to debate to a certain degree. And the Silence No More Act also requires an employer to give certain disclosures to employers if they wish to request a confidentiality provision in a settlement or severance agreement. For example, they have to advise the employee that they have the ability to go and speak to an attorney of their choosing, and they have a certain time period to do so. And then finally, it's not strictly related to confidentiality, but I typically see them combined with confidentiality provisions. But California also prohibits the inclusion of no rehire provisions in severance agreements, and that's important to keep in mind. Okay. Perfect. So now we're at the point where all of you that are licensed in Kansas, New York, New Jersey, and Pennsylvania, the code word to satisfy CLE requirements is California. And I will drop that code word into the chat as well. Okay. All right, next topic we want to touch on, even though we've been discussing it throughout the webinar so far, but is wage and hour overview and tips, which is an area that I in particular feel very passionately about since it's such an area of risk for employers in California. Okay, first on tap, I want to talk about the really exciting area of meal and rest break law, which sounds like it should be straightforward and a mundane topic. People take breaks when they work, and they should be allowed to. However, California has created a very rigid system that if it's not adhered to, it subjects you to that system of penalties that Sandy talked about earlier, and can, as I keep repeating, it can create high liability in this area. So it's especially important that employers operating in California have compliant break policies and practices in place. Okay, there are two distinct types of breaks in California. There are meal breaks, also known as meal periods, and rest breaks. Rest breaks, for those of you that are familiar with the Fair Labor Standards Act approach, rest breaks are akin to the traditional coffee break under that law. And the frequency and length of the breaks depends on the length of the employee's shift that they're working in a workday. So a rest break is typically 10 minutes in length. At a minimum, it needs to be 10 minutes in length. It must be paid, and the employee has to stay on the clock for the duration of the rest break. And an employee is entitled to a rest break for every 4 hours work, or the very enigmatic language of or major fraction thereof. And so what that means is at a minimum of 4 hours. So if an employee works a threshold of 3.5 hours, then they're entitled to their first rest break. And then if they work over 6 hours, they're entitled to an additional rest break. So for an employee who's working a normal 8-hour shift, they would be entitled to 2 10-minute paid rest breaks. And both meal and rest breaks, this is very important, and we deal with litigation on this topic all the time, is the rest breaks must be provided off duty and uninterrupted. So depending on the nature of the business, especially where in situations where an employee needs to man a cash register, or they're working the floor of a business, that means they need to be given coverage, and they need to be given the reasonable opportunity to take their break uninterrupted and off duty. And the same concept applies for meal breaks. However, meal breaks they must be at least 30 minutes in length, and they can be unpaid, and employees would clock out and record their time spent on their meal break. And similar to rest breaks, but even more rigid, they must be provided before certain times in an employee's workday. And what I'm providing is the general rules. But like Sandy mentioned, there are a series There are, I believe, over 16 wage orders in California that may provide additional nuances for different industries on the sequence and timing of meal breaks. But typically, employees must be provided a reasonable opportunity to take their meal break before they've worked before the 5-hour mark of the workday. And if the employee works more than 10 hours in the work day, they are entitled to take a second meal break, subject to limited waivers. It's limited situations where they can waive their rest breaks in writing, but they're entitled to a second meal break. And like I said, it's very important, especially given recent California Supreme Court decisions, that the meal breaks, the time that the employee is clocked out and taking their meal break, must be recorded. You can't it's very risky to automatically deduct, say, oh, they take their meal break every day, so I'm just going to deduct the 30 minutes because I know they're doing it. That is a recipe for a disaster. And so what's the penalty for not providing meal breaks in compliance with law? The statutes create a system where an employee is entitled to 1 hour of premium or penalty pay for each day they don't receive a meal break or a rest break. So in the case, assume an employee in the situation where an employee never takes any meal or rest breaks, they would be entitled to 2 hours of additional wages per day, 1 for missed meal breaks and 1 for missed rest breaks. Okay. And I'll briefly mention, and this flows into what I was just saying with respect to meal breaks and rest breaks, is that given a recent California Court of Appeals decision, time rounding is it's out of favor in California, and employers that are still rounding employees' work time are taking a serious risk by doing so. And the California Supreme Court decision that I mentioned a moment ago also says that meal period times cannot be rounded. Okay, and then moving on to the last topic I'll cover, and that is wage statements or pay stubs. And like everything else in California, it has a very rigid system with regard to providing pay stubs and what's included on those pay stubs. And there are essentially, I think, 7 or 9 categories of information that must be included on the pay stubs that are provided to employees. And the law says that these categories, they must be accurate. An employee has a right to receive an accurate pay stub. And you may say, well, that's fine. It's easy to get all of these 7 things right. But the issue with wage statements is the law also allows for what we call derivative wage statement violations. So in the example of if there's an issue in calculating the employee's overtime rate of pay, maybe there's even a reasonable debate about how it's calculated. But if it's found that it was not calculated correctly, there is an argument that the employee's gross wages were not reflected accurately on the wage statements, and it creates a derivative wage statement violation. And the penalties for above even other wage and hour violations, the pay stub violation penalties are very onerous. And it's $50 for their first occurrence and $100 thereafter, to a maximum of $4,000 per employee. So if you imagine having 100 or hundreds of employees, it can add up very quickly. Okay, and I'll turn it back over to Jessica.
Thanks, Carl. I am here to chat about pay transparency. Earlier this year, California amended its labor code to expand pay transparency for employees. So what this means is employers with 15 or more employees must include pay scales for positions and job postings, including if you use a third party cheat post the job. The California law does not specifically touch upon remote jobs or jobs that can be performed outside of the state of California. However, many other states have enacted similar laws that do touch upon remote work and work that can be done, or positions that can be done outside of those states. And so it's better to be safe than sorry, and just include the pay scale in the position, especially if you're a California employer. In addition, all employers must provide employees with the pay scale for their current position on request. And employers must maintain records of the employee's job title, wage rate history for the employee's whole employment and 3 years thereafter. In addition to these requirements, the government code was also amended to require employers with 100 or more employees or labor contractors to submit a pay data report to the California Civil Rights Department. This report includes data on the number of employees by race, ethnicity, and sex by position, as well as their mean and median pay rates by employee position grouping. This report is due to the California Civil Rights Department on or before the second Wednesday of May every single year. Moving on to Fair Workweek ordinances. Los Angeles, San Francisco, Berkeley, and Emeryville have enacted Fair Workweek ordinances, which requires employers to provide employees with 2 weeks advance notice of employee schedules. San Jose has enacted a similar statute, which requires employers to offer extra shifts or work to existing qualified part-time employees before hiring or retaining new employees. The definition of a covered employer under these various statutes differs. Some apply to all employers with a certain minimum threshold of employees, and others are more specific, such as retail firms, fast food employees, warehousing employees, etc. So it really is important to kind of take a look at the law and see, if you are a covered employer. But if you are a covered employer, you must usually provide at least 2 weeks advance notice of schedules to employees, provide a good faith estimate of work schedules in writing before a new employee starts their employment, offer additional hours. Say an employee has to miss a couple hours because they're sick, or takes a day off, offer those hours to existing qualified employees before hiring or retaining a new employee. And then pay predictability pay for changes made to schedules without a certain amount of notice. Predictability pay is usually 1 hour of pay per changed schedule, or per additional per changed schedule. And some cities require premium pay for shifts that are close in time, and some cities allow employees to decline extra hours or shifts that are close in time. And so moving on to practical tips for employers, I'll pass it on to Sandy.
Thank you, Jessica and Carl. I note that Jessica just addressed the Fair Workweek ordinances. This is a trend of laws being passed across the country requiring notice of scheduling well in advance, and requiring employer payments if the schedules that are put in place initially are changed. This is a huge transition for employers into a world where advanced scheduling and related pay for changes is going to be required. There will be, I believe, many more across the country. And the next segment is on practical tips for California employers. And what I try to do in doing practical tips is try to encapsulate many of the issues that we see national employers have over time that lead to litigation. So the first is, what is your contractual arrangement with most employees? And we recommend that for all but the highest level of employees, you should include at-will language in your offer letter or employment agreement. I mean, what does that mean? Well, executives sometimes have cause, no cause employment agreements. That's the opposite of an at-will arrangement. For folks who do not have executive agreements, we recommend written at-will language in your offer letter or employment agreements. When long-term employees are terminated, if there is no at-will language in the original hiring arrangement, that can lead to a breach of contract claim. Have employees acknowledge receipt and understanding of the at-will arrangement, and include an at-will statement in your employee handbook and have that acknowledged as well. So, but what does at-will employment actually do for you? It protects against breach of contract claims. I'm frequently asked by employers, isn't California an at-will employment state? And if so, can I be sued if I terminate an employee? And the answer is, of course, yes. Again, what at-will employment does is protect against a breach of contract claim. The contract is for at-will employment, but employees can and do claim discrimination, harassment, retaliation, or wrongful termination, violation of public policy. California is a hotbed of employment discrimination claims and breach of public policy claims. And so when terminating employees, that needs to be taken into account, notwithstanding that you have an at-will policy. What about executive employment agreements? Expect to pay out the without cause termination provision unless the conduct is particularly egregious. I find that employers will often have an executive employment agreement, and then when the agreement is terminated, think that they don't have to make the severance payment. If termination is without cause, you do need to make the payment. And if you terminate with cause, you're going to have to prove cause, which is not an easy thing to do in California. We recommend an arbitration provision in executive employment agreements. If you don't have an arbitration provision, then you would find yourself in front of a California jury trying to prove that you had cause for termination. But even with an arbitrator, there is a burden of proof attached to showing that you had cause for termination. Again, assume you'll have to pay out severance in accordance with the without cause provision. Require a release of claims in return for the payment of severance in your executive employment agreements. Try to avoid cure provisions. We see a lot of executive agreements with cure provisions. These are an impediment to termination. And frankly, I find it's almost 50-50 in terms of executive agreements. A client will enter an executive agreement and 2 years later call and say, now we want to terminate. If there's a cure provision, that can cause a problem. It's not recommended to attach a specific release in conjunction with an executive agreement. Instead, provide that a release will be required in return for severance, but don't attach the specific form. You'll want to negotiate that later. Another set of documents that we recommend with employees are confidential information and invention assignment agreements. These are recommended for all employees. And often an employer will say, but we don't need an invention assignment agreement. What is meant by invention is quite broad. You may not need an invention assignment from lower level employees, but it's definitely advisable for higher level employees. In conjunction with hiring, have a confidential information and invention assignment agreement. New employees are much more likely to sign without pushback. What about existing employees? Well, with respect to existing employees, it's recommended that if you now implement or change your confidential information and invention assignment agreements, then do it in conjunction with a raise in pay or with a promotion, so that it's clear that there's consideration. And again, you're more likely to get signature without pushback. The California Labor Code, section 2870, which is actually quite well known, but not by everyone across the country, must be cited for an enforceable invention assignment in conjunction with the California paperwork. So 2870 excludes an assignment of an invention developed on the employee's own time without using employer resources. This is typical in invention assignment agreements, but California Labor Code section 2870 must be cited specifically, or you don't have an enforceable assignment. Termination of employees. A member of any protected class can claim discrimination, harassment, or retaliation, frankly, at any time, and particularly in conjunction with termination. Clients outside California are often surprised at the types of claims that are made in conjunction with California terminations. Almost everyone is a member of a protected class in California and can make a discrimination, harassment, or retaliation claim, particularly when terminated. And although the law will say that the burden is on the employee to create a prima facie case of discrimination, in reality and practicality, the burden is effectively on the employer to prove it had a business reason for termination. That's how it really works in real life. One side point, I'm often asked, well, we know that we may need paperwork for termination, for work performance or conduct. We don't have it. Can we do a layoff instead? Inaccurately using layoff terminology for a one-person termination is a recipe for an employment disaster. Be truthful about what you're doing and why you're doing it. And let's talk for another moment about the protected classes. This is a list of the California protected classes. It is a very large list and demonstrates why almost everyone in California is in a protected class. So when Governor Newsom said, I don't need a couple of new protected classes, we already have enough, this is the reason. So when you're engaged in an employee termination, what protected class might that person be in, and what are the background facts that may support a claim, and how will you rebut that claim and anticipate that in the termination paperwork? And in that regard, I'm also often asked, well, you have so many rules and so many protected classes. How can I ever terminate anyone in California? Well, you can, and employers do, and without litigation, without claims, without litigation. Provide accurate performance appraisals. Do not promise progressive discipline, but you do use progressive discipline as appropriate. Documentation is key. Well-crafted termination letters are critical. And here I want to stop for a moment and address this. We recommend well-crafted termination letters when employees are being terminated, stating the business reasons for termination. That provides business support for why action was taken and makes it much more difficult to assert a discrimination claim. then the length and level of detail of a termination letter will vary with the circumstances. If it's a short-term employee who engaged in misconduct, a short termination letter may do. If it's a long-term employee without a lot in the file, then you're going to need a lengthy and detailed termination letter. We work with clients on an ongoing basis to assist them in drafting these types of letters. Again, without a termination letter, you may be faced with a termination demonstrating no business reason for the termination, allowing for a claim of discrimination. So the length and level of detail varies with the circumstances. Use attorney-client privilege for initial drafts. We can provide that, but if you're in-house counsel, stay out of the immediate fray of the disciplinary process and maintain your attorney-client privilege so that you can assist human resources with the documentation that's being done. Then the final draft is not privileged, but you've used attorney-client privilege to protect initial drafts of the documentation. So all of this should be done strategically. When you do a termination, you are potentially creating a legal claim. You need to think about it in advance and think about what your documentation is and what it will be. Other termination considerations. An employee, this is true in some other states too, but an employee has a right to obtain a copy of their personnel file in California. In California, you're given 30 days to produce it. Employee counsel is hoping for an empty personnel file, not substantiating the action taken. Nothing is better for plaintiff's counsel than to get an empty personnel file. A request for a human resources file is often advance notice of a plan to file a claim. And let me emphasize this point. We have frequently seen a careless termination. The employee go to an attorney and the attorney file then, well, a termination case? No, a wage and hour class action. One termination done sloppily, perhaps without considering whether to obtain a release agreement, can lead to a wage and hour class action. It happens frequently and emphasizes the importance of the careful handling of a termination. First thing plaintiff's counsel asks is, what were the wage and hour practices of the employer who terminated you? Use release agreements with employees, but do so strategically and not as the only documentation provided to the employee. I hate to see the only termination documentation in an HR file be an unsigned release agreement provided to the employee. And to conclude, a few unique but important laws. Your documentation should not require Californians to adjudicate claims arising in California outside California. California employees legally have the benefit of California law and adjudicating their claims in California. There's an exception for legal representation in negotiating the forum. In terminating short-term workers, be aware of Labor Code 970, which prohibits engaging workers to move from one place to another using false representation. So if you move someone from New York to California, or within California, and terminate them fairly quickly thereafter, they have a Labor Code 970 claim. This is yet another circumstance where you're going to need a termination letter citing the business basis for termination. And finally, I was just asked this yesterday. Can we prevent requiring California employees to refrain from discussing their wages? No. First of all, the National Labor Relations Act, which Carl mentioned, prohibits employers from telling employees who are covered by the National Labor Relations Act that they cannot discuss wages, hours, and working conditions. The National Labor Relations Act covers employees who are not supervisors. However, Labor Code 232, California, prevents employers from requiring any and all employees to refrain from discussing their wages. As we've noted throughout, California has an incredibly extensive set of employment laws. Often when we're asked the question, we do research. The laws are so complicated. It is impossible to know all of these laws and how to apply them if you're outside California. We stand ready to assist you and in any and all of your employment problems and questions. And with that, thank you to Jessica and Carl for their presentations today. We'll all be available to you afterwards to answer any questions. I'm going to turn the program over now. Thank you. To, may not come up for me, to Sam Maisel, who is a fantastic bankruptcy attorney. You'll be hearing from Sam Maisel and Tanya Moran, who are both resident in our Los Angeles office. And they will present on restructuring in the healthcare industry. You're about to hear from the preeminent national experts on this topic. Take it away, Sam.
Thank you, Sandra. It's a pleasure to be here. Let me see if I can take control of the slides. There we go. Anyway, so let me introduce myself. First of all, my name is Sam Maisel. I am the head of Denton's distressed healthcare efforts nationwide. I've been doing this for about 30 years. Started off as Medicare's bankruptcy lawyer at the U.S. Department of Justice many years ago, and then transitioned into private practice. With me today is the chair of the U.S. region for Denton's Restructuring, Insolvency, and Bankruptcy Group, Tanya Moran. Tanya, despite her youthful appearance, has also got decades of experience doing this work. And together with our group here at Denton's, we've done some of the really cutting-edge litigation in healthcare restructuring over the last 5-6 years in the United States, and we're going to talk about that litigation that we've done, the results we've achieved, and some of the real intricacies in what is an ever-increasing area of litigation in the United States. So first, I suppose the real question that comes up is, why should you care about this? Look, first of all, everybody has an interest in healthcare because obviously we all are tied into the national healthcare system. Unless you've been living under a rock, you're aware that the national healthcare policy has been a recurring political issue for decades now. The healthcare industry is enormous in the United States. It represents almost 20% of the gross domestic product. And this is much in excess of other Western nations, the European nations, for lots of historical reasons, national healthcare systems, which spend on average about half of what the United States does to provide healthcare to its citizens. And coming out of the pandemic, this industry has faced really enormous financial difficulties that Tanya's going to talk about. But some of it has also been systemic, right? Part of it is the way that the nation provides healthcare. The way the nation provides healthcare is sort of a Rube Goldberg-esque conglomeration of national health systems like Medicare and Medicaid, but also employer-based healthcare, which is sort of devolved from the World War II wage limitations. And so what you've got is this kind of Rube Goldberg-esque system, which provides healthcare, leading into the pandemic. The system had always had problems. And coming out of the pandemic, and I said Tanya, but I was I was wrong. I'm going to cover the next slide, which is going to talk about why they're in current financial distress. So first of all, coming out of the pandemic, a lot of nurses and doctors were simply overwhelmed by the pandemic and have retired or repurposed. And so what's happened is you've seen a greatly increased labor demand, particularly for nurses, but also as the economy has recovered from the pandemic, unemployment is down. And so the competition for even unskilled labor in the healthcare systems, competing even for unskilled labor with retail or hospitality has increased. So what you've seen is 3 and 4 times increases in labor costs across healthcare systems. We're all aware of the increased inflationary rates over the last 3 years. And of course, that just automatically increases supply costs for healthcare systems. A lot of the systems received enormous benefits, financial benefits, and subsidies during the pandemic from the federal and state governments. That is now coming to an end. So systems that had sort of been able to paper over operational or financial difficulties because they got these government grants, that's disappearing. Healthcare systems have very limited ability to pass on these increased costs for labor or inflationary costs, partially because the largest payors in the system are Medicare and Medicaid. And there, the government sets the rate for what they're going to pay you. Think of if you were buying shoes and the shoe store sets the price and you have to accept it. You can't go somewhere else to get health care from Medicare and Medicaid. And the government tells hospitals and other providers, this is what we will pay. And you can't pass on the increased cost. So, going back to the shoe store comparison, if a shoe store is paying 7% on its loans and needs to pass on that increase by raising the cost of the prices it charges for shoes, a hospital can't do that with Medicare and Medicaid. It has to accept what they pay. And although years from now, the inflationary costs will be worked through the system and will increase their compensation, it literally takes years to get that into the system, into the formula that sets the payments. So the hospitals and other healthcare systems are simply incapable of passing on the increased costs. And this applies to even private payors like Blue Cross Blue Shield, just to pick an example. A lot of those payors, and that's the term of art, they set their rates for what they'll pay, let's say for a hip replacement. They peg it to what Medicare pays. So they'll say, we'll pay 120% of Medicare for a hip replacement. And if it doesn't go up, if Medicare's payment doesn't go up, then neither does Blue Cross Blue Shield's. And those contracts are long-term. And so again, limited ability to pass on increased costs. Look, if you're in the stock market, a lot of large, particularly not-for-profits, so think Adventist or Sutter, they have huge market portfolios, some in the billions of dollars, that in theory, those returns on those investments can be used to subsidize the losses for the operations. That as the stock market's returns have slowed, obviously their return on their investments has slowed, so they have less money to subsidize the operational losses. Patient volumes have not recovered the way people expected from the pandemic. Look, there was a thought when that hip replacements went down because they were discretionary in some sense. And so there was a notion in the healthcare industry that coming out of the pandemic, there would be all this pent-up demand for procedures like hip replacements, which are low risk, high reimbursement. And so there was a sense that coming out of the pandemic, we would see this bow wave of patients returning because there'd been decreased patient presence during the pandemic. That just hasn't happened. And it's not clear why it hasn't happened, but it hasn't. And so as long as the patient demand, at best, it maybe in many places has returned to pre-pandemic volumes, but that, the sort of making up for the decrease during the pandemic, people, we're not sure where those patients have gone, but we're sure they're not back yet. One of the things that I mentioned was the 800-pound gorilla in healthcare is Medicare and Medicaid, right? They pay for the vast majority of healthcare in America. They pay for the majority of hospital services in America. So one of the issues that we've grappled with at Denton's, Tanya and I have grappled with in our cases, is how do you deal with these federal regulators that have enormous power outside of bankruptcy? And one of the advantages to a bankruptcy case has been our ability to get Medicare and Medicaid to the table, either to negotiate a settlement or to resolve the issues quickly in front of a bankruptcy judge. One of the first issues that we've had to deal with repeatedly is this jurisdictional bar that exists in the Social Security Act, and it's carried over into the Medicare Act by statute. And what it says at its heart is, unless and until a Medicare provider, I think a hospital here for purposes of this discussion, unless and until it goes through the Medicare appeals process, no federal court can take jurisdiction. So if you have a dispute, if you're a hospital and you have a dispute with the Medicare program, you must go through a 5-step appeal process before you can get to a federal judge to resolve the dispute. This appeal process has been historically just broken. It takes years to get through the 5 steps. The first 2 or 3 steps, which involve reconsiderations by the same entity that denied your claim or raised the issue to begin with, hearing before an administrative law judge, those are vastly likely to just reaffirm Medicare decision. And so you will have to wait years before you can get a federal court to resolve the dispute. And in the meantime, you are stuck in this nightmare of the Medicare appeals process. So obviously, one of the issues that we've grappled with in bankruptcy is, can we avoid it? And if you look at the language in front of you on the slide, you'll see that it talks only about sections 1331 or 1346 of Title 28 of the United States Code. Neither of those apply to bankruptcy courts. So what we've seen is a real, it's a tremendous difficulty for courts to deal with this, whether this statutory bar applies in bankruptcy courts. And right now, courts are split. So outside of bankruptcy, circuit courts have uniformly held that this bar applies even to provisions of the Uniform Code, United States Code, that aren't listed. But in bankruptcy now, circuit courts, 3 very important circuit courts, have held that bankruptcy courts are kind of unique and that they can take jurisdiction without the Medicare provider having to exhaust the administrative remedies. So here's 3 cases listed. Bayou Shores is the leading case for the argument that bankruptcy courts are stuck like other courts, and this jurisdictional bar applies to bankruptcy courts as well. So bankruptcy courts couldn't hear a Medicare dispute unless the provider, the hospital, has exhausted its administrative remedies. Now, one of the things that I want to point out here is the language in Bayou Shores. This circuit court is simply wrong, where it says the 7th, 8th, and 3rd circuits have held that Section 405H, the provision we just showed you in the prior slide, bars bankruptcy court jurisdiction, and 1334 jurisdiction is bankruptcy court jurisdiction. First of all, the 3rd Circuit has clearly held in a case called University Medical Center that, in fact, bankruptcy courts do not have to wait for exhaustion of administrative remedies. The 11th Circuit's just wrong here. The other thing it's wrong in this statement is the 7th and 8th Circuits have not ruled with regard to bankruptcy court jurisdiction on this issue. They have ruled in other jurisdictional grants that are not listed, the bar applies, but not in the context of bankruptcy court. So this sentence that we've quoted from the 11th Circuit is simply way too broad. Now, the 11th Circuit decision does hold, however, that bankruptcy courts are stuck, and the 11th Circuit includes Florida, which is a pretty busy healthcare jurisdiction. On the other hand, the 5th Circuit, which includes Texas, which is a very large jurisdiction, and Houston's been historically, or recently at least, a very active bankruptcy court. The 9th Circuit, which includes all of California, and it's not listed here, but in University Medical Center, the 3rd Circuit, have all held that bankruptcy courts do not have to defer to the administrative process. And so in the 3rd Circuit, which is Wilmington, a very busy bankruptcy jurisdiction, Houston, which is perhaps the second most busy jurisdiction bankruptcy court in the United States, and the 9th Circuit, which includes California, which is the 7th largest economy in the world. In those 3 jurisdictions, bankruptcy courts can take jurisdiction over a Medicare dispute without waiting for exhaustion of administrative remedies, which means bankruptcy is a huge advantage for a healthcare entity that is in a dispute with Medicare, because you don't have to wait for that 5 years of a hugely difficult, time-consuming, and expensive litigation in the Medicare appeals process. So I'm going to stop there and see if Tanya has anything she wants to add, and then we'll go to the provider agreements.
Sure. Thanks, Sam, and good morning to everyone, and good afternoon, depending on where you're sitting. Thanks for the opportunity to talk to you. Sam, I don't have anything to add, but I think what I'll do before I jump into the next slide is just step back a little bit. I'm not sure how many people watching this webinar have experience with restructuring, Chapter 11 cases, inside or outside of court. I'm not sure how many people have experience with a lot of the issues with respect to healthcare law. So stepping back, why this all matters to you and why it's important is because the hospital that you go to or that your mom goes to could be under financial distress and could perhaps have to close its doors or figure out how to sell its assets, right? And so when hospitals call Sam, when hospitals call me, when hospitals call Dentons, they are running out of cash and they're having a liquidity crisis. And so what that means is Sam and I are emergency room doctors for hospitals, right? When it comes to giving them tools to help them survive so that they don't close their doors. And this is really important because there's a lot of hospitals that, provide care in areas where there isn't another hospital for them to go to. So, think of a grandmother that's 85. If the hospital a mile from her closes down and she doesn't have transportation or has to wait for someone or get on a bus to get to a hospital 3 hours away, I mean, that's impacting, her livelihood, right? And so what we're really talking about is this intersection between healthcare law and the bankruptcy code. And our job is typically to work with the hospital and figure out, how do you keep your doors open? And how are you able to either sell this hospital to a buyer that continues care seamlessly, right? So that the hospital doors are open, somebody buys the hospital, you're still able to go to your doctor's visit, you're still able to get surgery, or maybe there's a way for the hospital to restructure its debt and to stay open. So why that's important is because when Sam talks about these Medicare statutes and exhausting remedies, if a hospital has to spend 5 years going through appeals because of a Medicare issue, they're going to close their door. They come to us and they're looking for an expedited way to solve their problems. And in the bankruptcy court, the case law Sam was talking about basically means we can give you a resolution in the bankruptcy court. The bankruptcy judge can preside over issues, and you don't have to go through these exhaustive appeals outside of bankruptcy, right? So that's key to helping a hospital in financial distress find solutions. And so with that, I'll transition into one of the most important things that comes up when a hospital or another entity is in a Chapter 11 bankruptcy case, is how you're going to treat these provider agreements, right? So a provider agreement basically is a hospital enters into a contract with Medicare. And that's how the hospital is able to treat patients and then is entitled to receive reimbursements from the program. And like Sam said, hospitals survive on these reimbursements once they treat their patients, right? So outside of Chapter 11, these provider agreements are really more of a statutory entitlement. There's a whole statutory scheme about these agreements, and they're not treated as a contract. But if there's a Chapter 11 bankruptcy, what happens is the government regulators, Medicare, make arguments that inside of bankruptcy, this provider agreement is actually a contract and is not a statutory entitlement. Why is that important? In a bankruptcy case, what happens is that the bankruptcy code says that if you have a contract, which is a quote unquote executory contract, meaning there's performance remaining on both sides, in order for the debtor, the company that filed bankruptcy, to assume and assign this contract, you have to basically cure any defaults. So if there's a contract, let's say a provider agreement, and it's treated as a contract, and there's $60 million that's outstanding, the debtor has to figure out how to pay this $60 million over to the regulator to be able to assume and assign this contract to a buyer. Not surprisingly, the debtor typically doesn't have $60 million sitting around to assume and assign this contract and to pay the $60 million. And maybe you're wondering, well, why can't this buyer just go get its own provider agreement? The answer is because that takes a significant amount of time. And there's also a risk that if they don't get a provider agreement, their own provider agreement, all the care that they have rendered during this time, they're not going to get any reimbursement for. So it's very routine in the heart of any sale that you actually have to deal with the provider agreements in the Chapter 11 sale. So we've successfully argued, and there's cases to support us, that the provider agreement isn't a contract. It's an entitlement, which means you can assume, which means you can sell it and you don't have to pay the costs that are outstanding, right? And so Sam just switched to a slide here, which is about a case we were involved called Verity Health. This is a case that we filed in the Central District of Los Angeles, 17 entities. Imagine this. There was 6 acute care hospitals operating at the time that the case files. So all over Los Angeles, all over the Bay Area, second largest nonprofit to ever file in history. So you can imagine how many patients throughout California are now wondering if their healthcare is going to be impacted because Verity filed bankruptcy. The answer is no, right? Our job is to make sure that there's kind of a seamless transition through the Chapter 11. There's a continuity of care. And the question becomes, well, what's going to happen to the hospital in this Chapter 11 case? In Verity, we ended up selling the hospitals. And as part of those sales, we had to deal with the provider agreements, right? And what the bankruptcy court ended up saying is that this provider agreement was in the nature of a statutory entitlement. It wasn't a contract. If you actually look at the contract, and Sam almost has the contract memorized verbatim, it's really a form. And there's really only obligations going from the hospital to Medicare, and in that case, Medi-Cal through DHCS, right? And so in the context of this case, we were able to sell the provider agreements just like other assets. And this is really important. Outside of bankruptcy, the provider agreements, when they get transferred, there's all sorts of potential liability that the seller has to pick up. So you can imagine that there might be overpayments that the seller would be on the hook for. And what is really a great advantage about 363, the bankruptcy code section that allows you to sell assets, is that you're able in bankruptcy to cut off the liabilities that you otherwise would have to assume outside of bankruptcy, right? And so this is one of the benefits that buyers like about bankruptcy. They get a protective 363 sell order that cuts off liability. So if you think about it, what that means is the buyer can take the assets, can figure out how to make a profit when maybe an otherwise hospital couldn't, and they could cut off these liabilities that really are legacy liabilities and have put the hospital in the situation that the hospital is in when it comes to distress. So for example, this could be a long list. In Verity, there was a long list of legacy liabilities, right? There was a lot of union agreements that Verity and the other hospitals were locked into that they couldn't change. There was a lot of different contracts with Blue Cross that they couldn't change. In terms of how they operated the hospital, the Attorney General had put conditions on, how many beds they might need to have in the ICU or in the NIC room. There's all sorts of conditions that really make it difficult for the hospital to figure out how it could change anything operationally to be able to succeed, right? And so all of a sudden in bankruptcy, you have the bankruptcy judge, you have the bankruptcy code, and you have the ability to start cutting off these liabilities so that a buyer could continue to operate, keep the doors open, but do it in a way that the hospitals are no longer in the same type of distress they were with the former operator. So I'm going to pause there and see, Sam, if you want to jump in.
Yeah, I just want to add one thought. So this is an area where the government is, if you're cynical about the government's behavior, this would contribute to it, because what Tanya described is really, I'll try to simplify it a little bit, because I want you to think outside of bankruptcy. For decades, the government has argued that this provider agreement is not a contract, and they uniformly prevail in that in federal courts around the country outside of bankruptcy, not a contract. At the same time, inside of bankruptcy, they have been arguing exactly the opposite. They're taking the same piece of paper, which in the case of Medicare is literally a single page, which the first paragraph says, if you're in the program, follow the rules. The second paragraph says, if you commit fraud, you'll be punished. Sign below. So they take that document, and inside of bankruptcy, they've argued with mostly success that it is a contract. So outside of bankruptcy, not a contract. Inside of bankruptcy, it is a contract. And, there's no logical explanation. They just get away with it. And partially they get away with it because people who are not familiar, bankruptcy lawyers are not as familiar with the healthcare provisions, and they look at that document and they're not familiar with the healthcare law outside of bankruptcy. And so there's not frequently argued, in defense of the lawyers, frequently clients, hospital operators, or healthcare entities do not want to litigate the issues because they're afraid of the government. Really, it just boils down to fear. So there's only been one or two decisions over the last 40 years since the bankruptcy code came into effect that deal with this issue where the government does not win, usually because it's not contested, on the treatment of a provider agreement as a contract. In Verity, this issue was firmly raised, completely litigated, and we got a very comprehensive decision, really cutting edge, groundbreaking law on this Medicaid provider agreement. Now, people, it is in the context of Medicaid, not Medicare, but in truth, the Medicaid provider agreement, the state provider agreement, looks more like a contract than the Medicare provider agreement. And the judge's decision in Verity relied extensively on non-bankruptcy decisions related to both Medicare and Medicaid. So we don't think there'd be a different result in Medicare litigation than there was in the context of the Medicaid litigation in Verity. And I think the federal government believes that as well, because right after we got the decision related to Medicaid in Verity, the federal government called up and settled with us in the context of Medicare. So I'm going to go now to another issue that comes up all the time in these healthcare cases, particularly with, again, Medicare and Medicaid, which is hospital, and it reviews them, and it has years to review them. So it might be 3, 4, or 5 years later that you'll get your audit done and be told you have an overpayment, or it could be ongoing for a bunch of different reasons, so that they decide there's an overpayment and the hospital owes them money back. There's two ways outside of bankruptcy. They simply send you a letter that says you owe us $100. You may you can appeal it, but in the meantime, you have to pay it. You have to pay the $100. Or if you don't send us a check for the $100, we will offset it from the ongoing stream of payments. So Medicare's, constant stream of payments for services provided to Medicare beneficiaries, and they will just take it out of that stream of payments. They'll just offset it against money they owe you this month to recover that prior overpayment from perhaps years ago. And outside of bankruptcy, that's an undisputed right. Inside of bankruptcy, it gets a little more difficult because bankruptcy has, in Section 553 of the Bankruptcy Code, very specific limits on set-off. And set-off is the right to adjust ongoing stream of payments to recover monies that are owed between the two parties, arising out of a separate transaction. And that's very tightly controlled in bankruptcy. And for example, one of the limits in bankruptcy is that you cannot offset obligations that arose before the bankruptcy commenced against monies that are being paid for services or goods provided after the bankruptcy filed. You can't cross the petition date to do the offset. Now, there is a wild card here, and that's the idea of recoupment. So recoupment is just an offset, except it arises out of the same integrated transaction. So think the same contractual relationship. If a party's offsetting the stream of payments to recover a prior overpayment and it's recoupment, the bankruptcy code does not stop it and doesn't address it. So Medicare has argued for years that its right to offset that ongoing stream of payments is recoupment, not subject to bankruptcy's automatic stay. And obviously, healthcare providers have argued it's set off, subject to the bankruptcy code's restrictions. So there's, again, a split in the circuits here. The Third Circuit, which again includes Delaware, a very active bankruptcy court, in the Third Circuit, in case of University Medical Center, the Third Circuit said, look, this stream of payments is limited by year. So think of a tax year here, an audit or cost report year, and it is an act of recoupment, but only if it occurs within the same year. So if the overpayment arose in But other than that, it's an active set-off subject to the automatic stay. And that is a huge benefit to healthcare providers because the government, historically takes years to decide whether there's an overpayment. So that ruling in the Third Circuit is quite important. And if, it sort of encourages entities that are going to file bankruptcy, if they can get jurisdiction in the Third Circuit in Delaware, it's a huge advantage if there's an overpayment issue. Unfortunately, here in the Ninth Circuit, the Ninth Circuit has held in the case cited there, TLC hospitals, that it doesn't matter if it's in the same cost report year, it's all recoupment, not subject to the automatic stay. So not as helpful in the Ninth Circuit on this particular issue, if that's the issue that's come up. And
Sam, I'm going to jump in real quick.
Yeah, please.
Sure. And by the way, I'm having moments where your audio goes out. And so if it's on my end and all of a sudden you can't hear me and others can't hear me, just jump in, Sam. I can't figure out if it's on my end or your end. Oh. But the one point that I just wanted to add to this, and again, this is stepping back and kind of real world, what is this about in the context of a Chapter 11 case, right? So Sam's walked you through set off and recoupment and how that works in a Chapter 11 case. You can kind of read the technical definition of recoupment and set off and understand the difference. I find that in practice, when you start getting into the weeds on these different programs and trying to figure out if it's recoupment or set off, it's a little bit like untangling, something pretty complex. Sam specializes in this area, so typically I just let him deal with it. But I want to make sure that the point that you take away, if you ever hear about this, is that in a Chapter 11 case, focusing on the liquidity issues of a hospital, by way of example, if all of a sudden Medicare regulators were able to start setting off and taking money from the hospital wouldn't be able to survive, right? That money they need for operations, to pay employees, to pay for supplies, etc. So a huge protection of a Chapter 11, and now the stay that protects the hospital, is that someone can't just set off, right? And that's really important, because even though you can recoup, as Sam said, most entities, most regulators aren't just going to start recouping without getting a blessing from the bankruptcy court that they have the authority to do so. Otherwise, they might violate the stay if they've construed it incorrectly, or if the bankruptcy judge disagrees with them, and then they're subject to sanctions, right? And so this is a really great benefit of being in Chapter 11, because again, the hospital is more protected, and now people aren't able to access their cash, and they're protected by the stay. So just wanted to add that, Sam.
Yeah, no, that's absolutely right. I mean, the point Tanya just made is so important, that this arises in the context of you've got a hospital, and some of our hospitals, rural hospitals, urban hospitals, they are 80% dependent on Medicare and Medicaid payments. And they operate at razor thin profit margins. I saw a study a couple of years ago that the hospital industry in New Jersey, for example, the average profit margin, in quotation marks, was 1%. So if you're 80% dependent on Medicare and Medicaid for payments, and you're only making a 1% profit margin, and then they decide to offset a huge overpayment to reduce your stream of payments, you're in the red immediately. So lots of times this issue, as Tanya pointed out, it's an existential issue to the hospital, because if this right of recoupment is recognized and the government just gets to offset the stream of payments, it can be the difference between the hospital surviving or closing. And again, as Tanya had pointed out earlier, that can frequently be the only hospital in the community and have a real dramatic impact on the community's healthcare network. There it is. look, this issue's really come up lately because because Medicare and Medicaid don't cover the cost of care, they generally pay somewhere between 70 and 80% of the cost of care, so that every Medicare patient, every Medicaid patient that a hospital treats, they lose money on it, which is why you read stories about how, hospitals are charging Blue Cross Blue Shield so much more than Medicare or Medicaid. Is because they have to make up the losses for treating those patients. The way the government gets money to hospitals is to create other programs. So one of the most popular programs to supplement Medicare and Medicaid deficiencies is a quality assurance fee program in California. It's called that. Sometimes it's called other things around the country, but it's basically a way to subsidize the losses that hospitals incur by treating Medicare and Medicaid patients. And what's happened in these cases now is the government has tried to offset the stream of payments to pay themselves on these quality assurance fees that haven't been paid. Because usually in every case, the hospitals have to make a contribution, then through a complicated system, the money comes back to them, subsidized by Medicare, by federal payments. So you pay in $1, it goes through the process, and it comes back to you basically as a grant, but $2 or $3. And so there's been a lot of litigation over the government's ability to offset, fee for service Medicare or Medicaid payments against these quality assurance fees. There's only two circuit court decisions. Gardens Regional Hospital Medical Center was the most recent one. The Ninth Circuit ruled that they could not offset, and that's one of our cases where we were able to, we raised the issue. We actually lost at the bankruptcy court, but prevailed at the Ninth Circuit, holding that they could not offset those ongoing stream of payments to pay themselves for the quality assurance fee payments. Okay, so as we mentioned at the beginning of the webinar, we need to take a brief moment to satisfy the CLE requirements by delivering the following code word. So all Kansas, New York, New Jersey, and Pennsylvania licensed attorneys must type the code word restructuring into the Q&A section of your screen. Please make sure to hit the send button so that it registers. And in case you missed it the first time, the CLE code word is up there on the screen. It's restructuring. So I'll give you a minute. And again, if you don't have a license in those states, you can just ignore this. Okay. All right. So I'll turn it back over to Tanya.
Thanks, Sam. So now we're going to talk a little bit more about 363 cells. So we kind of mentioned a couple of different times here selling assets in Chapter 11, and how issues may come up in terms of the Medicare provider agreement, for example. But now we're just kind of going to zoom out on a macro level and talk to you about how this actually happens in a case and the advantages of it, right? So consider now, for example, you're in a Chapter 11 case and you want to sell a hospital and all of a hospital's assets, right? How do you do that? What are the advantages of doing that in bankruptcy? And so in terms of a bankruptcy, what you see up on the screen is the section that provides the mechanism for the hospital to sell its assets is 363, right? And in terms of a sell in bankruptcy, there's the procedural aspects, and then there's the substantive aspects, and then there's the benefits to the buyer, right? So in terms of procedurally, how all of this happens is, you can imagine how, any other kind of movement in any case happens, you have to file a motion with the court. What you file is a motion to sell assets under 363. And it's a comprehensive process, right? At the first instance, you're filing a motion and you're saying to the court, you want to sell the hospital and the assets, and you are telling the court what your process is going to be to market these assets, right? Because in order to sell assets, what we typically do is we have to market the assets to make sure that we're getting the best price, right? And that we've kind of looked at all options in terms of sellers. There's a different process where you could try to streamline it and you could go through a private sale, but that's rare. And typically what we need to do is to go through the auction process to make sure that the company and the board are satisfying their fiduciary obligations to maximize value. So you file this motion, you tell the court you want to sell the assets, and you tell the court, this is how we're going to do it. And typically what that looks like is you tell the court about what your investment banker is going to do and what the timeline is, right? Because you need to get approval from the bankruptcy court to have your investment banker market these assets. It'll be like any other marketing in turn once you get the agreement, right? Except that it'll be faster, but you'll have your investment banker sending emails, contacting any potential purchasers of the assets that are interested. You'll have all sorts of deadlines. So a deadline by which anyone that wants to buy the assets needs to put in a bid. And then there's going to be all these requirements about what the bids have to include, right? Like financial information to make sure this buyer has the financial wherewithal, what the purchase price is going to be, what assets do they want, what assets do they want to exclude, and so forth. And so at the first instance, excuse me, I'm getting over a cold, you're asking the bankruptcy judge to approve this process. Once the bankruptcy judge approves the process, the company, the investment bankers, everyone is off and running, trying to get the best price for the assets. And if more than one bid comes in, you're having an auction. And usually this is an auction done outside of the bankruptcy court. And you are then getting your winning bidder and having the bankruptcy court approve that right after you go through that process. So with step one, you just say to the judge, I want to sell these assets, approve this process. As step two, you kind of go through the marketing process, pick the winner. And step three, you come back to the court, you tell the court who the winning bidder is. There's all sorts of briefing. Every party has an opportunity to show up and object or not object. And so procedurally, that at a very high level is kind of an outline of what it looks like. In terms of the substance, right, and I mentioned this earlier, what 363 allows you to do is to sell your assets, free and clear of any interest. What does any interest mean? I mean, that's like a very expansive definition in most circuits. And like I mentioned earlier, it's really helpful because if there's interest that are liabilities that are based on how the hospital operated its assets, for example, you can cut those off and the buyer has the opportunity to operate these assets and have these assets without those liabilities, right? So now maybe they can operate them more profitably and continue operations better than the prior operator, right? And typically, what you end up doing is you put your sell proceeds into an account and all of the liens may attach to those proceeds, and the hospital, the debtor, can be left arguing with different lien holders about rights to the proceeds, but the buyer gets to move on with its assets, right? And so again, you could end up having a collective bargaining agreement that's not advantageous, that the buyer wants to modify or wants to try to reject. That in and of itself is a whole bankruptcy code section and a complicated process that we go through, but all you need to know is that, again, this is another advantage of a 363 sale because you either have the modification or the rejection of that CBA. Separately, but similarly, think of a buyer now, they get to review all the contracts and all the leases that the hospital had. They get to decide, you know what, this is just a really burdensome lease. It's too expensive. It's not even market. This contract, I can get a better deal. I have another contract with this provider or this counterparty, and I can get a better deal. So the buyer gets to choose what contracts and leases it wants, and the ones that it does not want, the debtor will, quote unquote, reject those through the bankruptcy process. Again, that's 365 of the code, a whole different section. But I see that there is some notes coming in, but maybe that's just for us in terms of any IT issues. So anyway, that's at a high level, some of the substantive issues that deal with the bankruptcy code. And in terms of the benefits, I think I've touched on those quite a few times, right? That the buyer gets to cut off liabilities. They have this order that cuts off the liabilities. They also have this order that basically finds that they're a good faith purchaser, right? So that in the context of any disgruntled buyer or disgruntled party, when there's an appeal, those findings will help them in terms of they didn't enter into this deal with any type of collusion. They're a good faith purchaser. And typically on an appeal, if there's not a stay of the order, most time issues become moot, and we've argued that successfully, and the buyer is able to continue owning the assets, and there's no kind of disruption of the sale. In other words, it's not set aside, right? So Sam, is there something that you want to add in terms of 363 sales before I turn to the next slide?
No, thank you.
Okay, all right, great. So that's 363 sales at a macro level. Now I'm going to zoom in to nonprofit hospitals in Chapter 11. And when they want to sell their assets as a nonprofit, what does that look like, right? And so there's special rules if you're a nonprofit. And again, this is the work we do. We represent nonprofit hospitals. We help them solve their problems outside of Chapter 11. Short of that, if that can't happen, then we file a Chapter 11 for them. And most times it involves a sale of the hospitals. And the code basically says that a hospital in bankruptcy has to sell its assets, a nonprofit in bankruptcy has to sell its assets in accordance with non-bankruptcy law. What does that mean? It's not really clear, although we think we know what it means and we've litigated the issue, right? So if you're in Chapter 11, you're a nonprofit, you sell your assets, you have to go through certain state law requirements with respect to the Attorney General. There's all sorts of statutory law in terms of the Attorney General needing to and having the power and the supervisory role over the sale of nonprofits. Bankruptcy is interesting again, because now you have the intersection of the bankruptcy code, the judge, and the Attorney General. So this is built in to say that the Chapter 11 nonprofit has to sell in accordance with bankruptcy law, in accordance with state law. But what does that mean? In Verity, what we did is we submitted the application to the Attorney General, which is thousands and thousands of trees and explanations about the assets being sold, the buyer, you know, anything and everything that you can think of has to be submitted to the Attorney General. And under state law, the Attorney General either consents to the deal or either rejects the deal or either consents to the deal with modifications. And typically what we've seen is that what they do falls into the third bucket, which is consenting, but they're gonna like put conditions on this sale. Well, those conditions are really important because the conditions can be so onerous that the buyer walks, because then a buyer's not going to be able to operate the hospital at I'm getting a message that my internet's unstable. Hopefully you can hear me. You know, the buyer may walk if the Attorney General's conditions are so onerous. And so 363 could allow us to go in and cut off some of those conditions if they were historical conditions based on the performance of the hospital. So this 363D section makes selling assets for nonprofits a lot more complicated than if you just had your garden variety company in Chapter 11. Because now all of a sudden you get your sell order, which is great, but that doesn't end it. Now you start your state law process with the Attorney General, and you most likely end up having to come to the bankruptcy court for relief. And if you don't, then you know that's great. So the one other thing on this slide with respect to 363 is that in terms of a nonprofit and how its bankruptcy sale is different in Chapter 11, is that you can consider the charitable mission of the nonprofit. And so why does that matter? Why it matters is because typically in Chapter 11, the debtor is maximizing value. It's looking for the highest bid. Creditors want the highest bid. And that's what's important. But a nonprofit is different, right? A nonprofit needs to carry out its mission and needs to ensure that continuity of care. So all of a sudden you might have a lower bid from a buyer, but maybe that buyer is able to serve the nonprofit mission better than another buyer that put in a higher bid. By way of example, we represent Borrego Health in San Diego. It's a case pending in San Diego. Borrego Health has 16 clinics throughout San Diego and Riverside counties. And it's an FQHC, and it sold its assets. Everything I'm about to say is public. It sold its assets, and it chose a buyer that the board decided could carry out its mission because of the care that it had provided to vulnerable populations with HIV, pregnant women, and other types of vulnerable patients, and decided that it would carry out its mission better, and even though it had the lower price. In that case, both buyers actually paid creditors in full, which is rare. So we didn't have to litigate the issue. But the issue comes up, and it's not just academic. And, you know, a nonprofit does consider its charitable mission in addition to who's paying the most, right? Which is really your typical focus in a Chapter 11 garden variety case. So I'll pause there. Sam, do you want to add anything to that?
No, I think I'll go to the next slide because we're sort of running out of time and we want to end on time. You know, the last point that we talk about out of our cases is the case that Tanya's mentioned now, Borrego. We've actually got 2 cases pending now, both related to this issue of suspension of Medicare and Medicaid payments. So here's what happens. The government decides that they're investigating allegations of fraud or something else comes up, and they decide they're going to suspend all payments while they work through the issues. Well, again, an existential crisis for the healthcare provider because there's no cash flow for the company to survive while they work through the issues with the state or federal government. So in the case of Borrego, these clinics that Tanya described, heavily dependent on state Medicaid payments. The government decided to suspend the payments. We were able to go into bankruptcy court and get the bankruptcy judge to rule that the suspension would be a violation of the automatic stay. And so we were able to then keep the company alive, enter into a transaction, and keep the clinics, sell the clinics, but keep the healthcare system operational while we were conducting the sale. In a case called Curatech, which is a durable medical equipment supplier in Houston, the federal government shut off the payments. Again, we were able to go into the bankruptcy court. In that case, rather than risk getting unfavorable precedent, the federal government just turned the money back on through a settlement, and we're now negotiating a global resolution of the case.
And I think with that, we're out of time. So I know
Yeah.
we covered a lot, but hopefully you at least take away that Chapter 11 is a way to save hospitals and other entities. And if you ever have any questions, we're here. The most important announcement really is the announcement I'm about to make right now. In 30 minutes, you're going to receive a link. And this is going to be like a link that's going to help you with your CLE certificate. You know, your webinar login details, I've been told, is all really that you need. You don't need to take any other steps. And if you're in Kansas, New York, New Jersey, or Pennsylvania, you may, 30 business days. Sorry, you're going to get the link in 30 business days. And the code requirements are only for the states I just mentioned. So thank you again for your time.
Thank you, everyone.